Good morning, honorable members and colleagues. I think it's 10 o'clock. We must start with our meeting. Aska, are we correcting, or I can continue with the meeting because
we have enough members, Chair. We don't need to correct. It's a briefing, but we have enough members on the platform.
Okay. No, thank you very much, Aska. Let me take this opportunity to greet honorable members, honorable deputy minister from the department, official from the department led by Director General Ndadembele, our officials from Parliament. Honorable members, you know we are on recess, but because we have so many bills in front of our committee, we requested that day to come and receive the presentation from the department. That's why on recess day, we are attending the meeting. So I am not going to waste time to just talk. Let's move to the business of the day. Can we start by checking the apologies?
Chairperson, I've received none. Can you hear me, Chairperson? I've received no apologies for today.
What is the agenda of today?
Today's agenda,
before that, let me give Deputy Minister the platform maybe to tell us whether they do have the apology from their side.
Thank you so much, Chairperson of the Select Committee on Land Reform, Environment and Mineral Resources and Energy, and greetings to the members of the Select Committee. I just want to tender an apology on behalf of the Minister of Mineral Resources and Energy, Honorable Gwede Mantashe. Is having another commitment, but I'm here to represent the department. Thank you.
Thank you very much, DM. And then from your side, Ndadembele DG, Director General.
Good morning, Honorable Chairperson and Honorable members and Deputy Minister and colleagues. Chairperson, from our side, the team is here to present. There are no apologies. Thank you. Thank
you very much, DG. I'm not going to waste any time. Oh, let's accept the
Chair
agenda and apologies. Honorable Nana.
Thanks, Chairperson. Good morning, colleagues. I thought you were going to probably check with members if there are no apologies that we are required to submit. Honorable Labuskachne has asked me to tender her apology. She might join a bit late, but if she doesn't, please accept her apology. She has got another commitment in her constituency. In fact, the Premier of the Western Cape is visiting her constituency, so she has got to be with the Premier. Thank you.
Okay, thank you. Honorable members, any apology from your side before I can move to another item? Okay, honorable members, let me put these.
Sorry, Chair. Chair.
Yes, ma'am.
Good morning,
yes,
Chair, and
yes,
honorable members and the department. Chair, I wanted to register that if we're not finished by 12 o'clock, I'll be out because my constituency have a door-to-door, which is very important, is for all of us as MPs and MPLs. Thank you.
Thank you very much, ma'am. Thank you, Mama. Any apologies from you members? Okay. Honorable members, I put in front of you the apologies from both from the minister and from honorable members of the committee. Anyone who accept those apologies, and also the agenda of today.
Chairperson, I do move for the adoption of the agenda and apologies. Thank you.
Thank you, Honorable Bibi Mama. Any seconder?
Chairperson, Honorable Makwala.
Yes, Honorable Magwala.
Let me take this opportunity to greet the honorable members in the meeting and greet the department. I know you said that as a deputy minister in the meeting, which always that honorable Kwedamandache making excuses to come to this committee, but it's fine. I wanted to know what apologies are we adopting? We're on the road, busy doing the constituency work. Can you just repeat before people jump in and just let know, because we get surprises when we get minutes. That there were such apologies.
We receive apology from Honorable Laboskachny. We receive apology from Honorable Minister, but the Deputy Minister and Director Generals are in the meeting. Honorable Magwala.
Thank you, Chairman. Thank you for the clarity. I really appreciate it. Thank you.
Sure. Anyone who second Honorable Bibi?
I second the Honorable Bibi, Chairperson.
Thank you very much. DG or DM, let me give to you, you'll give the summary or political overview, Deputy Minister, and give to DG to present.
Thank you so much, Chair, for affording us an opportunity to come and present before the Select Committee on Land Reform, Environment and Mineral Resources and Energy, the National Nuclear Regulator Amendment Bill. Chair, the outline of our presentation is the department is going to be presented before the Select Committee is going to indicate that the bill that we are about to present seeks to amend the National Nuclear Regulator Act of 1999. It is also going to provide the Select Committee the context and the reasoning behind the proposed amendments. The public hearings undertaken by Parliament are going to be outlined as well on the presentation that is going to be presented. The objects of the bill as well as the provisions that have been proposed are going to be presented as well before the Select Committee. In the meeting, Chair, we have the DG of the department. He's supported by Mr. Nhlapo, who is the Chief Director Policy, and Mr. Zibi, Director Nuclear Policy, and our technical team as well is here in numbers. But then I'm going to hand over to the DG to take us through the presentation. If he feels that he needs somebody to maybe provide detailed information on the presentation, he's going to delegate accordingly. Thank you so much.
Thank you, DG. Yeah.
Okay. Thank you, Deputy Minister, and once again, good morning, Honorable Chairperson, Honorable Members, the Select Committee, Deputy Minister, and colleagues. DM, I'm in terms of the presentation, I'm just going to quickly run through the background and the some in terms of how we got here, and then I'm going to hand over to the Chief Director, Mr. Nhlapo, to take the members into the details in terms of the objects of the bill and the provisions that the bill is making. If we go into slide number 3, the slide on background. Yeah. The slide on background. I think the Deputy Minister has already indicated that these are the 4 areas. Chairperson, I'm not going to read word by word, but just to indicate that the bill that is in front of the members seeks to amend the National Nuclear Regulator Act of 1999. And this act establishes basically the National Nuclear Regulator, which regulates nuclear activities and provides for safety standards and regulatory practices for protection of persons or people, property, and the environment. The amendments that have been proposed on the bill are in the main aimed at aligning the Act with revised international regulatory best practices. And these are practices that are generally developed under the coordination of the International Atomic Energy Agency, of which South Africa is one of the founding members. The bill that is in front of the members was approved by Cabinet on the 24th of May 2023 for submission to Parliament, and the process that we followed is that then we submitted this bill to Parliament on the 25th of August 2023. We can go to next slide. We then the bill obviously started engagement in Parliament on the bill started through the Portfolio Committee on Mineral Resources and Energy in September, of which they undertook public consultations between September and October. And from that process, 29 written submissions were received and analyzed and engaged on. And this is in addition to that, there were also oral hearings that were undertaken in December by the Portfolio Committee on Mineral Resources and Energy. The bill was adopted obviously by the National Assembly on the 26th of March 2024, and hence we are here now presenting the bill to the Select Committee as part of the process in the NCOP. I will at this point hand over to my colleague Mr. Nhlapo to take the members through the details in terms of what is contained and the changes that are being proposed. Over to you, Mr. Nhlapo.
Thank you. Thank you.
Nhlapo, we can't hear you.
Apologies for that, DG. It was the sound was giving us audio feedback. Thank you, DG, and good morning to you, DG. Good morning to the Deputy Minister and honorable members. As you had outlined the background, honorable members, the objects of the bill is to amend, the main purpose is to amend the National Nuclear Regulator Act 47 of 1999. Chair, this is the bill, this is the legislation that regulates nuclear activities in the country. And the main objective is to align with international regulatory best practices. I think the DG had explained the context of the International Atomic Energy Agency. Is to align with that, and then is to expand the scope of the regulator's powers to perform additional regulatory functions. And it introduces other requirements that talks to issues of security and safe rehabilitation and decommissioning issues, and also introduces fines for non-compliances with the Act. So this this slide is just to give a high level, Chair. We are going to go into exact details of the proposed amendments on the bill. Can you move to the next one? Thank you, Chair. We are just trying to move to the next slide. Can you see the slides on your side? Thank you.
Yes, you can see.
Thank you, Chair. Chair, clause 1 of the bill, Chair. If you look at the bill, Chair and the members, honorable members, clause 1, when we refer to clause 1, we are referring to the numbering that will appear on our left in the bill. And then the section is the actual content in the bill itself in terms of the section that correlates with the Principal Act. So when we say clause 1, we'll be referring to that numbering on the left, but the section is the actual section of the Principal Act. So section 1 of the Principal Act, Chair, deals with definitions, and then clause 1 of the amendment bill seeks to amend that section to deal with the definitions so that they are aligned with International Atomic Energy Agency's best practices. And then in that exercise, Chair, the amendments also seeks to make certain insertions that were not there before and delete some of the sections or definitions which have become obsolete, Chair. And then clause 2 of the bill, Chair, seeks to amend section 2. Section 2 of the Act deals with an application of Act and declaration of nuclear installations. And Chair, the main objectives that are being amended under section 2, subsection 1A is an expansion of the scope of the application of the Act to cover activities of site evaluation, manufacturing of component parts, and extended shutdown. Chair, just for a contextual understanding, Chair, the application of the Act was that the Act itself applied to the siting, design, construction, operation, decontamination, decommissioning, and closure of any nuclear installations, as well as for vessels and to actions that were capable of causing nuclear damage. So these site evaluation activities and manufacturing of component parts and extended shutdowns were not included in the scope of the operation of the Act. And also from a contextual perspective, Chair, these activities that are covering the scope of the Acts are the ones that are being prohibited from being undertaken unless a person has an authorization to undertake the activities. So it really covers the scope of application of the Act and the activities for which the regulator exercises regulatory oversight. So that section seeks to expand that scope to include these activities. And then the section 2(1)(c) related to any action which was capable of causing nuclear damage. This is proposed to be deleted from where it was because it has been incorporated under section 2(1)(f). And then the new 2(1)(c) that is proposed to replace it is to extend the scope of the regulator to have oversight over unregulated radiation sources. And the radiation sources were covered under different legislations, but they've been integrated so that the regulator is able to also have oversight. So 2(1)(d) also is about expanding the scope of regulatory oversight to cover the National Defence Force facilities, equipment and machinery that needs to be released for civil use, including the rehabilitation of land that would have belonged to the National Defence Force and would have been used for radiation-related activities. This is to ensure that then the regulator is able to ensure that that land or those equipments or machinery or or scrap is properly cleaned up and safe to be released for civilian use. And then Section 2(1)(e) seeks to also expand the regulatory oversight to cover the exposure of a crew to cosmic radiation. This chair is similar to safeguarding the mine workers who are underground. So this is intended to ensure that those who are crew members also are safeguarded in terms of their exposure to cosmic radiation. Cosmic radiation is radiation that exists in the sky. And then, Chair, the last part of 2(1)(f), as I've mentioned it before, it was that 2(1)(c) that has been moved to 2(1)(f), which then becomes an all-encompassing provision that ensures that the regulator can cover any other activity that's capable of causing nuclear damage. And then Clause 2 of the bill, Chair, seeks to also amend Section 2, which deals with the establishment of the National Nuclear Regulator. This, Chair, is just to align with a common theme that is existing in the proposed amendments in terms of aligning with best practices and terminologies and concepts. Best practice concepts is that there are terms that have been substituted, like action has been replaced with activity, and then installations with facilities. So we'll find this theme cutting across the various sections in the bill. So in terms of Section 2, that was one of the starting point in terms of amending those activities to align in terms of the wording. And then, Chair, the other important one in terms of those proposed insertions is a new Section 2, subsection 2(e), which relates to the exclusion of regulation over naval vessels of foreign states that are invited into the Republic. This, Chair, has become a problematic implementation challenge for the regulator because of the nature of confidentiality that exists in the naval forces and the access to naval vessels that are visiting. So this is amended to exclude that. However, naval vessels will still be regulated through the diplomatic channels, and the regulator still retains regulatory oversight in the event of an accident that can happen where a naval vessel is docked. Because when they are invited, then they make sure that they put all the measures in terms of security, of compensation should there be damages and things like that. And then in terms of Section 2(2)(f), it excludes the application of the Act to nuclear security matters that are covered under the Nuclear Energy Act of 1995. These are nuclear safeguard matters, because that legislation provides a framework on how to regulate those nuclear safeguard matters. And then Section 2(3), Chair, relates to the powers of the minister to declare areas to which the Act would apply or not apply in terms of being excluded from the application of the Act. But then the regulator, the amendments are to ensure that the regulator can make recommendations to the minister to declare a facility to be a nuclear facility. Previously, this was done after consultation with the minister. So the proposal now is that it must be made on the recommendation of the board to the minister. Clause 3, Chair, seeks to amend Section 3, which deals with the establishment of the regulator. This is just an alignment amendment that seeks to ensure that it's articulated that the regulator is a Schedule 3A entity in terms of the Public Finance Management Act. There are various other provisions that we will cross-reference to or will come to, Chair, which also are aligned with just aligning the bill or the Act with the PFMA or the Public Finance Management Act. And then Clause 4 of the bill seeks to amend Section 5. Section 5 is in the Principal Act, deals with the objects of the regulator. And these objects, in terms of the proposed amendments, Chair, is to align it to ensure that the protection of persons, property, and the environment is against harmful effects of radiation associated with nuclear facilities and activities. This is one of those amendments that are informed by international evolution of regulatory practices in the nuclear space. It was generally called against the harmful effects of nuclear damage. But now this has been extended or revised to ensure that it refers to the harmful effects of radiation. Because then from nuclear facilities, this is where you can get exposure that results in nuclear damage, and from activities you can get radiological sort of harm. So this is to align those kinds of concepts, Chair. And it also includes related security standards. This also aligns with the developments in the nuclear space in terms of safety, security, and safeguards. They call it the SSS approach, whereas our legislation previously only covered safety and did not cover security. It only covered safety and aspects of safeguards. And then, Chair, Section 5B is just one of those textual alignment to align the section with the previous amendments that would have been made. And then Section 5C is proposed to be deleted, Chair, because it has been covered under Section 5B of the Act. And then also, Chair, in terms of that explanation I provided earlier about use of terminology and replacement of terminology. So 5D, E, and F are just textual alignment of those terms and concepts. And then a new proposed Section 5G, Chair, is an insertion that will empower the regulator to disseminate information, Chair, concerning its activities and their effects on the environment, for the protection of persons' property and the environment from the facilities and activities that are being regulated. So this is an empowerment provision for the regulator to be able to disseminate information, Chair. And then, Chair, Clause 5 of the bill seeks to amend Section 6(1)(a). Section 6 is about cooperative government. This is a section that sought to enforce the constitutional principles of intergovernmental relations and ensure that there's a integration of activities from all different activities that are undertaken by different regulators. So that provision is just extended to ensure that radiation hazards are also included in that scope, because it was limited only to nuclear hazards. The next, thank you. The next, Clause 6, Chair, seeks to amend Section 7. Section 7 of the Principal Act covers or deals with functions of the regulator. Chair, the starting point of the functions of the regulator is that it has powers to grant or amend nuclear authorizations. And then the scope of nuclear authorizations in terms of the Principal Act, it was limited to granting or amending nuclear authorizations. So this is being amended to also include powers to refuse, suspend, or revoke authorizations, Chair. And then Section 7(1)(b), Chair, is that alignment, seeks to align with the PFMA, when the regulator processes or undertakes activities of procurement or acquiring assets, it must be done in terms of the provisions of the PFMA. So this is that alignment. And then the bulk of Section 7(1) and those subsections from C to J, are textual amendments to align the bill in terms of those terminologies and where there were changes. And then the new insertions, Chair, are under new Section 7K to S, Chair, and Section 7K to S of the bill, Chair, seeks to increase that scope of the regulator, Chair, to ensure that the issuing of directives and assessing of activities of applicants for authorizations and enforcement measures in case of non-compliances and seeks to introduce measures to ensure that there's a maintenance of a national dose register. A national dose register, Chair, is a register that is intended to keep records of people who are exposed in terms of their different activities, so that they are kept in the loop to ensure that they are not further exposed, Chair. And also the maintenance of that national register of radiation sources. Radiation sources, Chair, there has been no framework for ensuring that there's a national register for keeping the sources as to where they are and where they are found. And there's been challenges around lost or derelict sources. So that new insertion seeks to expand that scope of the regulator to ensure that their functions also covers all those areas. And then next, please. Section 8, Chair, of the Clause 7 seeks to amend Section 8 of the bill. And then Section 8, Chair, is the one that deals with the control and management of affairs of the regulator. These provisions are the ones that talks to the issues of the boards, establishment of the boards and the powers and duties of the boards, the qualification of board members in general terms. So the proposed amendments are simply textual in the sense that board of directors is to be replaced with board, because in the definitions now, a board of directors has a definition which has been defined under a board. So it's to align that. And then the Section 8.4a is to replace, this is also a textual amendment, Chair, where previously we were referring to Department of XYZ, and now is to replace that with the department responsible for an activity. So in the case of the Mineral Resources and Energy, is to replace Department of Minerals with the department responsible for Mineral Resources and Energy. Equally so under Environmental Affairs is to replace that with department responsible for the environment. This, Chair, is to prepare and to ensure that when there are reconfigurations in terms of ministries, the relevant ministries or the relevant ministers in those ministries still retain the specific reference without necessarily going to amend the Act to align with the configurations, Chair. And then in terms of Section 8.4c, is a new insertion that has been proposed to add a member of the board. The Chief Executive Officer of the organization was the only executive representative of the board. So this seeks to add the Chief Financial Officer of the regulator to become a member of the board. And then this is also to align with the governance, evolution in the governance space. And then Section 7B is Section 7, Section 8, subsection 7B is to substitute the original provision provided for the minister to appoint a panel that will do a short listing of members of board candidates. So the proposal there is to replace the minister with the portfolio committee of the relevant portfolio committee of the National Assembly that is going to do the shortlisting and hand over the listed candidates, and then the minister then retains the prerogative to appoint board candidates to become board members. And then in terms of Section 8.7d, it's just to replace the discretion there with an obligation for the minister to appoint alternative board members for representative board members. Yeah, thanks. The point around the board members there was that there are board members who are representing departments, government departments, stakeholder representatives like labor, persons of communities affected by nuclear activities. So that obligates the minister to ensure that alternative members are also appointed. And then we are still on clause 8, Chair, section 8. The section 8, 12A and B, Chair, seeks to deal with the period of appointment. The original or principal legislation provided for an appointment for a period of 3 years. This is proposed to be extended to a 5-year period. And then 813, Chair, this was just proposed to be deleted because it provided that then the replacement director will do the same duties that were done by the previous one, but the appointment letter then will articulate the role and scope of the activities of under that appointment. So that provision is superfluous. Section 814, Chair, dealt with the transitional provisions when the regulator was formed and it was moving from the Council for Nuclear Safety to become the National Nuclear Regulator. So these were provisions that were safeguarding the interest of the employees when they transited to the next entity. So that has been achieved, and that the proposal is to delete those provisions. And then a new section 815 and 16, Chair, just are insertions that designates the board as the accounting authority. This is also to align with PFMA issues, and then sets out the standards and qualifications must be possessed by members of the board. This is also to introduce a standard that board members need to meet up with. And then, Chair, clause 8 seeks to amend section 9. Section 9 is about the vacation of office of board members. This is to align with that textual arrangement of replacing board members by director. Then clause 9, Chair, of the bill seeks to amend section 12. Section 12 of the Principal Act deals with the committees of board, but this is also just a textual amendment to align with that replacement of terminologies. So nuclear authorization is there replaced with an authorization holder. And then, Chair, clause 10 seeks to amend section 14 of the Act. Section 14 dealt with the delegation and assignment by board. This is just to include that scope because the delegation and assignment by boards was limited to board members, to a chairperson of the board or a committee of the board. So the proposed amendment is to include a director or chief executive officer as people who also may be delegated or assigned to do certain board activities. And then clause 11, Chair, seeks to amend section 15. Section 15 of the Principal Act contains the deals with the chief executive officer of the regulator. This is also about the appointment, powers, duties, and obligations of the chief executive officer. Here also, Chair, the process was that the minister, after consultation with the board, would have appointed a suitable person to be a chief executive officer. That 15.1 is proposed to be amended to enable the board to make appointment recommendations to the minister. And that recommendation also includes a particular number of persons that can be delegated, that can be recommended, and then the minister has a discretion to appoint. And then the 15.3, Chair, this proposal is also to align the term of office of the chief executive officer to align with the term of office of the board from 3 years to 5 years. And then the 15.5A, Chair, is proposed to be deleted. It was also linking with that transitional period from the Council of Nuclear Safety to the National Nuclear Regulator. That has also become fulfilled and is now redundant. The provisions are redundant. And then the proposal for deletion of section 15.6c. 15.6c, Chair, provided for almost the chief executive officer to issue a nuclear authorization. And this power, Chair, of issuing nuclear authorization is the power of the board in terms of the provisions of the bill. So this was just to align and delete this section so that certainty is provided for. And then from section 15.6d and 15.9a, these are the amendments that are aligning with the PFMA. The Public Entities Act has been replaced by the PFMA. So these are consequential amendments to align the bill. And then also 15.10 is just a textual amendment to replace employee with staff members. And then deletion of 15.11 is also the powers of an acting chief executive officer. This will be covered in the letter of appointment or designation for somebody to act. And then clause 12 of the bill seeks to amend section 16. Section 16 dealt with staff of the regulator, Chair, in terms of the Principal Act. And the main amendments there are the deletions of section 16.3, 4, and 6, which align with that explanation around transition from Council of Nuclear Safety to the nuclear regulator. So those have been fulfilled. And then clause 13 also seeks to amend section 17. Section 17 deals with the funds of the regulator, Chair. This is to amend the scope, expand the scope of the source of funds of the regulator to include fines that are levied. This, Chair, aligns with the proposed amendments later on in the bill that seeks to introduce a system because the Act was only limited to criminalization of non-compliances. So then those fines that could be levied for non-compliances become the additional source of funds of the regulator. So this is to align that. And then section 17.7 is also proposed to be deleted, Chair, because now it's the PFMA alignment necessitates that this be eliminated, be deleted from being a duplication. And then, Chair, clause 14 of the bill seeks to amend section 18. This is also one of those small amendments that seeks to align with the financial year of the regulator, is to align this to be in line with the PFMA or determined in terms of the PFMA. And then clause 15 is just a textual amendment of the heading in terms of replacing that heading. The heading was nuclear authorization. It replaces that with nuclear authorizations because now the scope of nuclear authorizations have been amended, effected in terms of later on in the chapter, Chair. And then clause 16 seeks to amend section 20. Section 20 of the Principal Act dealt with or deals with restrictions on certain actions, Chair. And since this is a regulatory legislation, Chair, what happens is that, and I mentioned this earlier, that activities are prohibited unless they are undertaken under an authorization issued by the regulator. So section 20 is that provision that prohibits activities, so that then it prescribes a process of how you apply to get an authorization to do that. So that scope that I mentioned earlier when we were dealing with the scope and the objects of the legislation, under section 20, we have those activities. So the proposed amendment is to expand that scope to provide for additional activities that cannot be undertaken unless they are undertaken under and authorization. And this talks to those that we mentioned earlier. There are also pre-construction activities, manufacturing of component parts. So those are the activities that are extended in that provision. And then clause 17 seeks to amend section 21. Section 21 talks about the process now. Since there's a restriction, then there must be a process for somebody to apply so that they can get or obtain an authorization. So section 21 deals with the application for a nuclear authorization or vessel license. And it sets out the procedures for persons who wish to obtain those authorizations and how they would go about doing that. So the amendments are to ensure that those extended activities are also included in those scope of activities. Section 18, clause 18 seeks to amend section 22. Section 22, Chair, deals with an application for a certificate of registration or exemption of certain actions for certain actions. This, Chair, also the restrictions are twofold. There are ones that relates to nuclear facilities which are covered under section 20, and then section 22 deals with all the other activities which would not have been covered under section 20, which are covered by different forms of authorizations. So section 22 also starts by providing that persons wishing to engage in those activities that are articulated in that section needs to apply for a certificate or an authorization to perform those activities. The distinction and difference between these two sets of applications and authorizations, Chair, is that the authorizations that are carried under section 21 or the provisions of section 20 and the authorizations that are under section 21 relates to facilities, and they draw a nuclear liability that is a strict liability, whereas the activities that are taking place under section 22 draw a common law liability in terms of the actions or activities that are undertaken there. So one is for facilities, one is for ordinary actions and activities that takes place in the space. So section 22 sets out the application process for the other activities and empowers the regulator to conduct examinations when applicants are lodged, and then provides for validities for authorizations and when such authorizations may be renewed. And then clause 19, Chair, seeks to amend section 23. Section 23 of the Principal Act relates to conditions that relate to nuclear installation licenses, nuclear vessel license, or certificate of registrations. So those terminologies are those that have been replaced by facilities and activities. So the amendments under section 23 is to provide that alignment with those forms of authorizations and then the references thereto. And then clause 20 seeks to amend section 24, which covered special conditions related to nuclear vessel licenses. This is also textual amendments in terms of aligning with the forms of authorizations. Similarly with section 24, which is sought to be amended. And section 24 also, in terms of clause 26 to amend section 24 as also talking to textual amendments. And then clause 21 talks to section 25. Section 25 is a provision that prohibited the transfer of nuclear authorizations. So the proposed amendment is to provide for conditions under which an authorization may be transferable. And then clause 22 seeks to speak to the amendment of section 26. Section 26 contains the responsibilities of holder of nuclear authorizations. and it extends and clarifies the responsibilities of holders of authorizations in terms of their responsibilities, because the core principle in the regulatory space is that an operator bears the prime responsibilities for their activities. So this aligns with that scope to ensure that is clarified. Clause 23 seeks to insert a new section 26A, Chair, and then section 26A of a proposed section 26A seeks to introduce the financial responsibilities for authorization holders. So they are required to set aside financial responsibilities for rehabilitation of land where they undertake their activities when they come to their end of life in terms of their activities, and then remediation of sites as well as decommissioning activities. So generally rehabilitation relates to restoring the land to the habitable situation, and then decommissioning relates to facilities, nuclear facilities. So this introduces a requirement that all the operators need to set aside funds or financial resources so that when their activities reach end of life, they are able to rehabilitate, remediate, and decommission successfully and safely. And then clause 24 of the bill seeks to amend section 27. Section 27 relates to the revocation and surrender of nuclear authorizations. This just clarifies the circumstances under which an authorization may be suspended, modified, revoked, or surrendered. And this aligns with what we mentioned earlier in terms of the empowering of the regulator, not only to grant or refuse, but also to be able to do these activities that are covered under section 27. Clause 25 seeks to insert a new section 28C, Chair, and this is about the scope of the fees that can be determined, because previously the regulator would source its funds from activities, licensed and licensable activities. But the evolution is that sometimes there are activities that are not necessarily licensable, but operators or people come to the regulator and seek guidance and seek an assessment of certain activities. This is to empower the regulator to be able to raise fees from those activities. And then clause 26, Chair, seeks to amend section 30. Section 30 deals with strict liability of holders of nuclear authorization for nuclear damage. This, Chair, is what I was explaining, that there are different liability regimes. So section 30 introduces that strict liability for holders of nuclear holders of nuclear licenses for facilities, Chair. So this is to align the wording in terms of that alignment that we mentioned earlier. And then the important insertion around this provision of section 30 is an inclusion of a new subsection which provides for when liability will end in relation to strict liability. This is also one of the developments around the nuclear liability regime internationally, as to there was no clarity as to when exactly does liability end, and liability must end when the material that belongs to somebody who's bound by this strict liability comes into the site of another person who's also bound by such liability regime. So this seeks to provide that clarity. And then clause 27 seeks to amend section 32, Chair, of the Act. Section 32 of the Act deals with the liability of a holder of certificates of registration. So as I mentioned, the different authorizations and their different liability regimes. So section 32 is also textual amendments to align the terminologies in terms of the references. Sorry, Chair. Apologies, and also to do that textual sort of amendment, because then the definition includes the reference of compensation for occupational injuries and diseases. So it's just to align that because it has been defined. And then Chair, clause 20, where was I? Clause 29 seeks to amend section 34, Chair. And then section 34 of the Act, Chair, deals with prescriptions. If I miss something, Chair, I think around section 33, it's just textual amendments that aligns the terminologies. And then section 34 is about the prescription of actions, Chair, for strict liability as to when those, a right to claim, when does it come to an end for somebody who would have suffered nuclear damage. And this is to protect persons who have suffered damage, to make sure that they can have access to relief and claim and launch claims for nuclear damage suffered. And they are able to amend their claim to take into account any aggravation of damage that can happen after the expiration of the prescription period, provided that courts have not entered into a final judgment. This, Chair, is to cover the stochastic effects of radiation damage, which can manifest after periods of 20 years. So prescription period in terms of the legislation here is limited to 30 years. So if somebody can pick up damages or damages manifest after 20 years, they'll still be able to now launch claims without them being precluded on the basis of by the time when the damage happened, they would not have known that they have suffered damage. Thank you. Next. Clause 30, Chair, of the bill seeks to amend section 35. Section 35 deals with or covers compensation for injuries of regulators' employees. This is also a textual amendment, amendments that seeks to deal with the references to Compensation for Occupational Diseases Act. And then clause 35, sorry, clause 32 amends section 36. Section 36 is the key provision in terms of this legislation, because it's the one that empowers the setting up of safety standards and regulatory practices. So the scope of that is being expanded to include security matters. In terms of, it was limited to safety standards and regulatory practices, safety and emergency. So now it includes also security measures, so that then there is an empowerment to set up regulatory standards and practices around all those areas. And then section 30, clause 32 seeks to amend section 37. This is also alignment with textual amendments, but section 37 deals with the duties regarding nuclear accidents and incidents. There's textual amendments, and there's a new proposed insertion of a section 37(6), which obliges the regulator to act as an advisor to emergency response organizations in terms of emergency preparedness and response. The regulator is being empowered to provide certain advisory services to response organization and government organs when there's a nuclear radiological emergency. And it also includes, thanks, Chair. And then clause 33 of the bill seeks to amend section 38. Section 38 is the main provision that covers emergency planning. So it also aligns the textual amendments and inserts new sections 38, subsection 5 to subsection 12. These are the provisions that extend the role of the regulator in emergency planning for emergency preparedness and response. And it sets out also factors that needs to be taken account for the preparation of emergency plans, as well as coordinations of amongst the relevant organizations who play a role when a nuclear emergency occurs, and the requirements for several role players, including the role that government plays. The Principal Act was silent on delineation of these roles and the interface that must take place in terms of emergency planning for nuclear emergencies. And then clause 34 of the bill seeks to amend section 39. Section 39 deals with the record of nuclear installations. It's a provisions that talks to the keeping of records of nuclear records. This is also a textual alignment that talks to that replacement of installations with facilities and nuclear license with an authorization. And then clause 35, Chair seeks to amend section 40. Section 40 deals with the records of nuclear accident and incidents and access thereto. So this also expands the scope of the regulator in terms of the records that must be kept, must also include radiation accidents and incidents. It was limited previously. And then clause 36 seeks to amend section 41. Section 41 deals with the power and appointment of inspectors. These are the professionals who go and do the inspection to ensure that there's compliance with the Act and the safety, security, and protection of persons is done. There's compliance with license conditions and all of that. So this also is to align it with these textual amendments, but importantly is the introductions of a new sections 41 for E, 3 and F. Chair, these insertions, Chair, are actions, are activities that empower regulators, the regulators, inspectors to be able to dictate to a holder of an authorization as to limiting or prohibiting persons to continue to undertake work in areas where they are exposed. So this is to force the protection of employees to ensure that they do not continue to be exposed when an operator has not complied with license conditions, as well as to ensure that there's a safely securing of nuclear or radioactive material should an activity be suspended, so that that material can be stored safely without it posing a threat of exposure. And then the new section, another proposed insertion under 41.6 is to indicate the period of validity of a decision of an inspector, because that was silent previously. There was no provision as to when a decision of how long or is a decision of an inspector valid. And then clause 37, Chair seeks to amend section 47 of the bill. Section 47 of the bill deals with regulations, Chair, and this scope of the regulations are being expanded to empower the minister to prescribe a schedule of administrative fines that needs to be imposed by the regulator. This aligns, Chair, with that explanation that the Act was previously limited to non-compliances were only regarded as criminal offenses, but then the proposal is to introduce a measure of non-compliances that could attract administrative fines. So this empowers the minister to be able to prescribe, on the recommendation of the board and the Minister of Finance, after consultation with the Minister of Finance, a schedule of administrative fines. And then section 38 of the bill seeks to amend section 48. 48 dealt with delegations and assignment by minister. These are the delegations to the Director General. And this is also to deal with textual amendments in terms of the references to the ministry. And then Chair, Section 39 of the bill Clause 39 seeks to amend Section 49. Section 49 of the 49(1) of the bill, Chair, was previously limited to only sections where these were recommendations on the amount of security, categorization of nuclear installations, and safety standards and regulatory practice. But Section 49(1) now has been amended to include all the sections where, in terms of the proposed amendments of the bill, there are provisions where the regulator may make recommendations to the minister, and this 49(1) seeks to address a scenario where a minister raises or has a concerns around the recommendations that have been raised as to what happens to those recommendations. So 49(1) was only limited to those 3 or 4 sections, but now they cover all the other sections that have been proposed that introduce powers to make recommendations to the minister, so that in the event that the minister does not agree with those recommendations, then the minister and the board must endeavor to resolve their disagreements. And then Section 49(2) is to clarify that should there be no resolution of a disagreement, then the minister retains the final decision to making that decision after consultations with the necessary parties. In this instance, it's in the relevant sections where there's a Minister of Finance involved and the Minister of COPTA, then the minister must, after consultation with them, make a final decision. And then Clause 40, Chair, of the bill seeks to amend Section 51. Section 51 is about disclosure of information. This is just an alignment on textual alignment amendments. And then Clause 41 seeks to amend Section 52. Section 52, Chair, is the provision that provided for offenses and penalties. And this is being amended to introduce a process that seeks to cover an issue where an administrative fine has been prescribed and there's non-compliance with that. Then it brings that non-compliance ultimately back to the fold of what needs to be done in terms of that process, and to ensure that ultimately, even if administrative fines are introduced when they are delinquent operators, then non-failure to pay the fines after due diligence processes have been undertaken can be also a criminal offense, can be criminalized. And then Section 42 of the bill, Chair, Clause 42 of the bill, Chair, is the last one, which provides for the short title and commencement of the Act. The other sections, Chair, have been dealt with and are not included in the scope of amendments, Chair. And with that, Chair, I think this brings. Can we move to the next? It brings us to the end of the presentation, Chair. And thank you, Chair. And I'd like to hand it back to you. Thanks. Mute.
Oh, thank you very much. Now, Niti, if you want to add something, you can add before I give to members. Or
No,
DM.
thank you, Chair. Okay. Thank you, Chair. I thought I should officially hand over to DM, but just to emphasize that I know that a lot of information was shared in terms of the provisions of the bill that are being made in the bill, but just to sum up by reminding the members that all these changes are obviously aimed at doing about 5 things, which is aligning the Act with international regulatory best practices, expanding or further empowering the regulator for the regulator to be able to adequately perform its functions. And third, to introduce requirements for operators to obviously be able to set aside money for safe rehabilitation of land or decommissioning of nuclear facilities. Lastly, to introduce administrative fines to manage non-compliance in the space. In the main, all these changes in the bill are aimed at these 4 or 5 things. I will hand over to DM Chairperson.
Thank you so much, DG and the team, for tabling a comprehensive report before the Select Committee. Chair, DG has said it all. Back to you. Thank you.
Thank you, DM and DG. Let me start by welcoming the presentation and give to honorable members. Here is the presentation of the bill. I'll see by raising of your hand if you have any question or you want to comment. Okay, on the platform, I see Honorable Nana and Honorable Mamgwe. Let me start with Honorable Honorable Nana, Honorable Magwala, and Honorable Ngwe.
Thank you very much, Chairperson, and good morning once again to colleagues and everyone else on the platform. Chairperson, in the presentation, the department says the department talks of a board. Now, I know the bill cannot go into finer details such as the composition of a board. That is more of an administrative function. But I would want to check, because in the presentation, we are told that the tenure of the board has been 3 years now. It's been extended to 5. I would want to check whether is this in line with international practice. In other words, what is the tenure of similar boards in countries elsewhere in the world? And speaking of the board, Chair, I would also want to know whether in the skills set sought for this board, has a consideration been given to people from other countries who might have skills that are necessarily not readily available in a country? And lastly, on the advisory role of the regulator in an event of an emergency, I would want to ask, is the regulator going to be charging for this kind of services? Thank you very much.
Thank you very much, Honorable Nana. Honorable Magwala.
Thank you, Chairperson of the committee. Am I audible?
Yes.
Okay, thank you, Chair. Let me thank the department for a comprehensive presentation, and thank the Deputy Minister taking his time to come and do this important bill of nuclear. Now, I just want to welcome the presentation, Chairperson. With no too much further, because I've researched a lot, I could see that the NA have done quite a very good job. The only thing that I wanted to check with the presenter or the DG or the Deputy Minister is that they've never told us in terms of the public hearings what was the objections. I'm very much interested what people objected in terms of this bill, because when the presentations are done, we're only told about the submissions, so many, and these are the submissions that came through in terms of those NGOs, your unions, whatsoever. I'm only interested in the objections of those ones, but as the economic freedom fighters, we support this bill in terms of this nuclear bill. Thank you, Chairperson.
Thank you very much, Honorable Magwala. Honorable Mamo Mangweng.
Thanks very much, Chairperson, and good morning to all the members and the department. Also, thank you, Chair, for recognizing me. Chair, I welcome the presentation of the department. And my question, Chair, I want to check that we'll focus on the proposed amendment as reflected in the bill. On slide 6, Chairperson, they said they mentioned that this amendment bill seeks to expand the scope of the regulator powers. Now, Chair, I wanted to check what are the examples of the powers and the function that the bill seeks to expand. My second question, Chair, is on slide 12. I want to check what is the rationale to extend the period of the holding office by the chairperson of the board and directors from 3 to 5 years. Can you give details explanation on this matter? My third question is on. I want to check, Chair, what I wanted to check on whether the repeat offenders will always be subjected to a fine when not comply with the act, or will they be prosecuted and if found guilty, be sentenced to prison? Can you give example of the type of the penalties which the bill seeks to impose to license holders? And also, I want to check that is it the position of CFO a new position? If no, why is it only now that the CFO has to become a member of the board? I thank you, Chairperson Kelly-Walker. Thank you.
Thank you very much, Momo. Honorable Magwala, I see your hand. Is it a legacy hand or a new hand? Honorable Magwala? Oh, it means it was a legacy hand. Okay. No, thank you very much, honorable members, for your questions. I can see no one wanted to ask question. Let me give back to DM and DG to respond your questions. DM, DG.
Chairperson, I can,
okay.
I can go from my side. Maybe DM is having a challenge on her side. Chairperson, I'm going to respond to touch on some of the questions that have been raised, and then I'll give to the colleagues to respond to the others in detail. I think that maybe let me start with the question that was asked by Honorable Nana on the skill set. The general principle from the department is that when we appoint boards, we do this by issuing adverts and out to the public for either people to nominate or for people to apply to be placed on the boards. And what we do is we look at a mix of skill sets on the board, and those include technical, commercial, legal, and human resource skills. So we normally take an approach that ensures that the boards that are appointed have a diversified skills mix. And specific to the question around will a consideration be given from people from other countries, I would say consideration is generally given to everyone who applies, and post application, obviously we do undertake the process, obviously, of vetting people and all that, and anyone who obviously meets the technical criteria and is probably the preferred candidate, and they pass, obviously the vetting process will be considered for the boards in the department, various entities, including for this particular entity. There was a question around, again, from Honorable Nana, around the role of the regulator in emergency. Will they be charging for the services? The regulator's job is to regulate the sector and make sure that the sector complies with prevailing regulations. And in conducting these activities, it is standard practice that the regulator does not necessarily charge for this, but obviously if there are additional cost as a result of whatever activity that the regulator has to undertake, which are not necessarily as a result of the powers of the regulator. I mean, if there's an emergency on the side of one of the licensees, obviously the licensee carries the cost of ensuring that the emergency is managed, and the role of the regulator is to obviously provide oversight and ensure that the situation is managed and brought to normality. In terms of the question from Honorable Nana around the tenure of the similar boards, I think in the main, the colleagues can comment if they have I don't have the numbers, but what we have realized is that for most boards and for continuity and to ensure that the boards make the maximum impact, our observation is that providing boards with a shorter period of time, sometimes what happens is that by the time the board is now coming to speed with the operation of the entity and they're making an impact, we suddenly then have to change the board. And that obviously impacts on the operations of the entity, but also on the strategies, because these entities generally develop 5-year strategies in line with obviously the administration that they are serving under. So it brings obviously a continuity and certainty if you get the tenures to be long enough and be aligned. The question from Honorable Magwala around the public hearings, there were obviously public hearings that the department undertook as part of public consultation in drafting the bill, and the colleagues will touch on those. And there's the public hearings that obviously the Portfolio Committee on Mineral Resources and Energy conducted, and I would take it that obviously the report from the committee will provide the details in terms of the committee's view on those hearings, but the colleagues will talk to the comments that we received during the drafting of the bill. The ones from the Portfolio Committee on Mineral Resources and Energy, I think it will be fair to request that then obviously the members refer to the report from the Portfolio Committee instead of us almost coming here and speaking on behalf of the process that the committee undertook. And Then I think I spoke to then there's the questions around from Honorable Ngwenya on the specifics, and I will allow the colleagues to give the examples. I think the honorable member asked for examples on the expanding the powers of the regulator. What are examples of those? I've spoken to the issue of the rationale, and then the member also asked for the rationale, sorry, for the tenure of office. The member also asked the question around the example or requested examples on what happens to offenders, the type of penalties that will be imposed. And the member also asked the question around the position of the CFO being the member of the board, and the colleagues can also touch on that. I think you can comment on the questions I've not responded to, which are mainly the request for examples from Honorable Member Ngwenya, as well as what was the status of the CFO prior to this change. And
Thank you, TG, and thank you to the honorable members. And thanks, TG. I think you have covered a lot of the questions, Chair. Chair, I think what I will just start to address from my notes in terms of the areas that probably the DG would have touched on, but probably just at a high level, the issues of what is the tenure of under the issues of boards, what is the tenure compared to other jurisdictions. And I think, Chair, this also will relate to the rationale for the expanding of the period of 3 to 5 years, but the DG would have dealt with that. Comparing to other jurisdictions, Chair, in terms of the international jurisdictions, most of the nuclear regulatory bodies have their chief executives and their boards are appointed for 8, some of them have 8 years to 10 years. They provide for longer, very much longer period of appointments because they link that with the security of tenure. But there are also others who provide for it for a 5-year period. So the spread is almost balanced between the 5-year period to 7, 8 to 10-year period. So that is the tenure that they normally provide for. But when we also compared the tenures nationally in terms of our other jurisdictions, other regulatory entities in the country, the uniform position is around the 5-year period, which aligns with the MTSF periods and strategic planning cycles that we have. So that was the tenure compared to other jurisdictions. So 5 years is the mostly settled on period because it also has a proviso for an extension of that period for another term, which then brings it then to 10 if it is extended for the same member or same person. And then the issue of the example of the expansion of the regulatory powers and what it seeks to achieve. And an example that we will use, for example, is that informed one of the specific case is the issue of the scope of the regulator to be expanded to have oversight over the release of Defence Force facilities and land for civilian use. An example of that kind of a scenario which happened and fell into the cracks and proved to be detrimental was there were some scraps, airplane, this fighter jet scrap material that was released and the regulator did not have oversight. and it ended up with scrap dealers who sold it into the international market. And South African scrap, when it reached the international market, was picked up as having been contaminated with radiation, and that almost brought a huge damage to the sector, to the steel sector, in terms of what comes from the country and gets sold internationally. So from that exercise, then that's one of the lessons that were learned, to say these activities there must be oversight, so that then when they have to release their assets for civilian use, there's an oversight that provides assurance that these are safe to be used, as well as the land, when people have to settle on the land, which previously belonged to the Defense Force. Then the regulator needs to provide that assurance that it's safe, because radiation, it has been rehabilitated, and it's safe for people to occupy. So that's one example I would offer. And then the other questions that I would talk to was around the issues of from Honorable Ngwenya, around the issues of repeat offenders. Will they be subjected to a fine or sentence? I think the proposed amendments are to ensure that first, I think the regulator then, when a system of fine gets rolled out, it uses a system that they call a graded approach, where they'll do an analysis and assessment as to the severity of the non-compliance, and issue fines around that. But should then that repeat offense happen around that, one of the proposed amendments is that could be regarded as a criminalized, as a criminal offense, because Section 52 of the Principal Act does provide for offenses and penalties, and it links this with the other provisions in the bill or in the Act, and provides for the nature and type of offenses that accompany such contraventions. So for the serious offenses, for example, it provides that people who are convicted on those serious offenses can have a fine or imprisonment for a period of not exceeding 10 years. Those are considered the high-level non-compliances. And then for the other less severe ones, there's a fine or imprisonment not exceeding 5 years. And then the inclusions are also to include a lesser period that aligns with the failure to pay certain fines, which are purely administrative in nature, but to deter repeated non-compliances with those. So that will talk to addressing that question, Chair. And then the other part was, I think, around the CFO being made a member of the board. Chair, the developments that we've picked up around benchmarking of legislative developments around regulators and the compositions of boards demonstrated that in line with the corporate governance prescripts that are being implemented by boards, chief executive officers, chief financial officers are being included as ex officio members of boards, in addition to chief executive officers. So that is the rationale that we have picked up. It has also come as well from the regulator, as well from the challenges that they've been experiencing in terms of their activities in interfacing with boards. So that this is also informed by those best practices. Chair, I think the other question was from Honorable Makwala around I think the DG would have touched on this, but at a high level, in terms of the inputs that we received from participants who participated in the public participation processes, all the participants, Chair, supported the bill. They supported the proposed amendments. Most of the concerns that were raised were around clarity issues and the scope as to whether is it limited, should it be extended to exceed what it is now. But the general attitude of all the people who commented was they were in support of the bill and they supported the provisions of the proposed amendments. I think, Chair, TG, unless there's something I'm missing that I'm not aware of, I think I would have covered all the questions that we are standing, and we appreciate the support for the bill, as Honorable Magwala has mentioned. Thank you, Chair, and thank you, TG.
Thank you, Dr. Chairperson, those are the responses that you're providing to the questions that have been asked. I'm just trying to see, I don't know if DM is now able to.
Yes, I'm here, DG.
Okay,
I don't know the
those are
technology. Okay, thank you so much. Chair, the team led by the DG has indicated that I think the document itself during the public hearings was clear. Hence, the team is indicating that the bill was supported by all stakeholders. And it is already indicated on the presentation that has been tabled before the select committee that everyone was happy with the amendments that are being proposed. To emphasize just on this issue of the expansion of the regulatory powers, Chair, and the members of the select committee, is to ensure that the regulator performs its functions effectively and efficiently as to guarantee the South Africa's compliance with international obligations. Hence, IAEA is the entity that set out standards that we should indeed comply with these best practices. So we're trying to close those gaps that have been identified. Lastly, Chair, I think the gentleman again from our team, DMRE, indicated that it is trying to close a number of issues and factors that have been identified. For instance, it is trying to strengthen the regulatory framework for nuclear safety, which is going to contribute in ensuring the protection of persons, the property, and environment against harmful effects of radiation and nuclear damage. So we believe that this bill is progressive and it is indeed responsive to the needs of the sector as well as the best practices as far as IAEA is concerned. Bringing back the meeting to you, Chair, I believe we have touched to a number of questions that were raised by the select committee. Thank you so much.
Thank you very much, DM and DG, for responding to all the questions that members has asked. Honorable members, let me check with you. Do you have any question that you are not satisfied with the answer from the department? None. It means honorable members are happy with the presentation, are happy the way you responded to their questions. So by so saying, Honorable Deputy Minister, I can say you can say even I think it's our last meeting with you guys, if I'm not mistaken. You can say a word to the committee before. Oh, Honorable Ngwenya, I can see your hand.
Thanks very much.
DM, wait first, DM. Let me check with Honorable Ngwenya.
Thanks very much, Chair. Since this is our last meeting on this sixth parliament. Also, Chair, I would like to thank the department to work with them for all this term. We're working very well. In terms of the questions, Chair, that I've asked always in the committee, the department is answering our question very well. I would like to thank that Chair, and thank you for the response that I've got it today. Thank you.
Thank you very much, Honorable Ngwenya. DM, I think somebody's talking.
Should I come in, Chair?
No, wait first, DM, somebody was talking. Oh, okay. Yeah, DM, can you give us a closing remark from your side and thank the committee for being with them since you take over from our late Deputy Minister? DM?
Thank you so much, Chair, and members of the Select Committee. Chair, is just to appreciate the fact that you have been supportive towards the portfolio, towards the department itself, and you know, we did not take all your questions negatively. They were empowering throughout the term of office since the sixth administration started. And the minister as well appreciate the level of constructive criticism that we have been, and the marching orders that we have been receiving from the Select Committee. And we believe that through these processes that were empowering us, we are better versions of ourselves than before. And we wish everyone the portfolio in the Select Committee well, since we're approaching our seventh administration. All the best to you all, and we enjoyed working with you. It's been a very positive journey to us. Thank you.
Thanks,
you very much.
my dear.
The whip, Mom Bibi, do you want to say something before I release the department?
Okay, no, Chairperson, there's not that much to say. Thank you from the department. And thank you so much for listening to us and ensure us you take us very serious. And when we scold you guys, you always humble yourselves and be in front of us. Thank you so much, Teshe, the DM. I'm sorry, guys, to select Teshe as a DM because it's from my province and he's from, you know, my leader at the same time. Thank you so much also to the department and also the board that is here. I mean, thank you so much for everything. Okay, thank you so much, Chairperson, for the opportunity.
Thank you very much, Ma'am Bibi. Honorable Nana, do you want to say something?
Well, thanks, Chairperson. You know, it's always a problem when you give veterans to speak before memos like me. You know, now Umamu Ngwenya, no Mamu Bibi have really summed it up nicely. But from our side as the Democratic Alliance, Chairperson, thank you very much for the opportunity. I do think it's really appropriate to have one or two words. Really, we met as strangers when we first met. You will remember I contested you for the chairpersonship of this committee. We met as we met as complete strangers. Today, if we part ways, we will part ways as colleagues and comrades. And I can't really emphasize the cooperation that we've always received from the Ministry of Mineral Resources and Energy under the leadership of Wati. it's been an amazing journey for myself and I'm sure for my colleagues in the DA, having had a rare opportunity and privilege to serve with people of your caliber. Thank you very much, and God bless.
Thank you very much. Honorable Magwala. Magwala, do you want to say something?
Yes, thank you, Jefferson. I was also taught that when your principal has spoken, you must not spoke. As I subscribe myself and believe in the democratic socialism as a left movement of economic freedom fighters in our lifetime. We also like to just pass word of appreciation from the department itself overall, and the deputy minister for always availing himself to us. You know, many people take NCOPS by the way, not knowing that there are so many bills that we can turn back and change and do whatever we want. At the center of everything, we are the ones that do the concurrence in these bills. In terms of actually, we are the principals of the three spheres of government. But anyway, Chairperson, I also like to put the words of appreciation to the department, the minister. I've came in at a short space of time now, but I've learned a lot. The department does take the community very much seriously. I've seen the deputy minister always coming to our meetings. Now and then, the principal, which is the minister, when it's available, he will always come in and have a chat with us and respond positively with a very comprehensive bill today. Presentation was proper as all the time. Thank you very much to the administration side as well for doing a very good job. And we hope and pray that the seventh administration will be led by the EFF and Minister of the EFF after 29th of May. It will be a new journey to work with the TG and everyone in the department. And with those words, I say thank you very much, Chairperson, for the opportunity.
Thank you very much, honorable members. DM, DG, and your team, I hope you'll convey the message to the deputy, to the minister himself, to say this select committee, they really appreciated to work with him and his team. I remember when we met for the first time, it was like we are enemies. When we look at back where we come from, I think it was a long journey. A journey that was full of sadness and happiness, criticisms, constructive criticisms. But at the end of the day, it makes us a good people. We are better people today because of being working together with this team. We can stand there and talk about all the things that we have been doing with the department. But from the onset, we didn't know anything about Department of Mineral and Energy. It was a very strange thing. But today, like I'm saying, we are better persons because of this department. We really thank you, Deputy Minister. We really thank you, DG, and also the Minister. We wish you good luck in your new administration, the seventh administration, and treat the committee, the new select committee or the seventh select committee like you treat us. We don't have any regrets for being working with you. We feel sadness when we supposed to apart because we were home, we established the relationship, brothers and sisters in this committee, but when some are taking another direction, some are taking another direction, it's a painful thing, but thank you very much. We thank you. Go well. Thank you, DM. And now you are released with your team.
Thank you.
Thank you.
Thank you so much, Chair. Bye, guys.
Bye. Aska, before 12 o'clock, Mangwenya left us.
Yeah, Chairperson, we don't correct. We'll have to carry the meeting, the minutes over to the next meeting, Chair.
We are correcting, Aska.
No, Chair, we don't do. Ms. Labuskaghni left, so that leaves us with 4 provinces that can vote.
1, 2, 3. Oh, okay. No problem. No problem. Thank you. Honorable members, we will meet next week. Thank you very much. And for your taking time to leave your constituency, to leave everything, but to come to this meeting and also participate. You were not in the meeting just because you are in the meeting, but you participate very well. Thank you very much. See you next week, the 16th. I wish you well in your campaign and take care of yourself. Bye-bye.
Bye, Chair. Thanks very much. Bye.
Oh, my goodness.
Bye.
Beautiful.
Sunday.